Hello and welcome to UBLUR-TV. I'm your host, Brad Harmon, and today my guest is Brant Stevens, attorney at law in Spokane, Washington. Brant, welcome to the broadcast.
Hello, Brad. Thank you.
We're so glad that you could take time out of your busy schedule to join us today. Now, Brant is a family law attorney in Spokane. Can you tell me a little bit about what kind of family law cases you see most often and who you can help the most?
Well, I deal with a lot of divorces in family law, Brad, and one of the common issues that comes up in a divorce proceeding is child support. And I wanted to talk a little bit about child support today. Child support is fairly straightforward. Generally, you're required to file your most recent pay stub and 2 years tax returns to document your income. And then the income of the father and the income of the mother is combined into a combined net income. And from those figures, they are plugged into a child support guideline that's provided by the state of Washington. And the child support calculation then is derived from the standard income figures that are provided by the state of Washington as far as a party's child support obligation.
That's good to know. So those funds are used to take care of the kid while they're being raised by the guardian parent?
Right. So then the custodial parent, whoever that is, as determined by the court, receives the child support from the non-custodial parent, and those funds are intended for the financial support of the child, but they can include, for the custodial parent, there's always a housing expense, there are always living expenses. So a lot of the times the money isn't seen directly by the child, but and there's nothing that the obligor parent or the person paying child support can do to ensure that his child support payment is paid directly to the child. The child support payment is intended for the financial support of the child in the custodial parent's household, and so there's a lot of discretion with the custodial parent as to what the child support obligation, what those funds are actually spent on.
Well, that's good to know. So child support's a very big issue when it comes to family law and the divorce cases that you see.
That's correct, Brad. It's a fairly straightforward calculation. A lot of the times clients will come into the office and they'll confuse child support with maintenance. A maintenance issue is a completely different thing. The maintenance is for the support of your spouse. And the classic maintenance situation is family unit, divorce comes through the family unit. The mother has been a stay-at-home mom for generally a large amount of time, needs financial support from the husband who has been able to build a career for himself, has the financial means to take care of himself, but as the father and mother separate, the mother then needs some continued financial support from the father in order to make her now separate household continue to function and continue to pay her bills and provide for her family. So the maintenance, in my opinion, in the state of Washington is one of the more difficult issues. The law surrounding when a party is determined to be in need of maintenance is fairly ambiguous. The keystone or the touchstone as to where you start in determining a maintenance issue is need and ability to pay. And there are several other factors that the court will consider in awarding. Generally, it's the mother in a case, but I've had some cases where the father has had a need for some maintenance. Excuse me, Brad. And so the need and the ability to pay is a starting point when you're doing your maintenance analysis. And that is, the father generally has to have the ability to pay some maintenance to the mother. The mother has a need as far as just continuing to maintain her household, paying the mortgage, food, in addition to the child support that she may be receiving. She needs that extra money. Maybe she's going back to school. Maybe she's doing some retraining in the field that she's interested in. And so all those factors come into play, and that's what makes maintenance such a tricky issue in the state of Washington. And I would say, as to the one issue that's litigated most often in the state of Washington, maintenance in the divorce setting is the most litigated issue in the state of Washington.
Well, that's good to know, Brant. Thanks for sharing that with us. Now, in your law practice, can you help either side of the argument, or do you focus on one or the other?
No, I will help either side of the argument. Both sides generally will present good arguments as to why there should be a maintenance or maintenance payment, or as to why there shouldn't be a maintenance payment. And so whether it's the mother or the father, my obligation is for zealous representation of both sides in the divorce, and that's what I try to do, and that's what I strive to do. So
that's good to know. Thank you for sharing that. Now, we know that when family law issues pop up, there's always lots of other financial issues that pop up into it. What other financial issues may you need to deal with in financial law that you can help someone with family law that you may need to help with?
So I wanted to just bring up the issue of post-secondary support. I think a lot of the times when people go through a divorce, once it's finalized, they forget that when the child turns 18, in the state of Washington, there's still there's law in the state of Washington that provides that both parties in a divorce have an obligation to continue to support the child through their post-secondary education. And by post-secondary education, I mean college. And so the party's obligation, once you've gone through a divorce, doesn't stop at 18 for children. It continues on through college. And one of the parties, either the father or the mother, has to petition the court by the time the child usually, and you have to read your child support order to determine actually when you have to petition the court for your post-secondary support. But generally, it's by the time the child either reaches the age of 18 or graduates from high school. And if neither party petitions the court for help with college, by the time the child graduates from high school or turns the age of 18, then that issue becomes moot, and neither party can ask the court for child support. So, for example, if one of the parties wants to help the child with their college, and the other party doesn't want to help the child with their college, and that creates a situation where it's simply unfair or unequitable that one party is willing to, the other party is not willing to, and the party that is willing to will generally file for post-secondary support. The court will generally allocate the cost of college between the parties on a third basis, meaning the child pays a third, one of the parents pays a third, and the other parent pays a third. The 2/3 that the parents are to provide support, post-secondary support, can get a little bit skewed based on income. If one party makes significantly more than the other party, then they may have a greater portion of expense for the post-secondary support obligation. So that's an issue that often gets overlooked. It can be an issue that has a significant financial effect on the child and on both parents. And so I just wanted to bring that up quickly today, Brad.
That's good to know. I appreciate you bringing that up because that's not something that gets thought of very often. And let's face it, when we have children, we're their parents for their whole lives, not just till they're 18. So thank you for sharing that with us.
That is true.
And appreciate your wisdom and counsel on family law today. Thank you for joining us.
Yes, you're welcome, Brad.
And thank you for joining us on UBLUR TV. I hope that we'll see you again soon on another broadcast.